So I'm making this video because there's a lot of disinformation being spewed about the recent developments in the Tobago House of Assembly, where 13 assemblymen and associated officials resigned from the Progressive Democratic Patriots, the party that won the THA election held on December 6, 2021. And I believe quite firmly that this kind of disinformation is being done because the people doing so are quite certain that most of us will never bother to read the materials they're referring to. And while I'm sure their belief may have some merit, it does not apply universally, as some of us will take the time to do the reading. My hope in doing this video is that while you may not be interested in doing the reading yourself, you'll at least be interested in a presentation of what is written in those materials so that you, for yourself, can determine if people are trying to pull the wool over your eyes or not. So, without further ado, let's listen to a portion of what attorney Martin George said a few days ago in a post on Facebook, and then let's examine it for its validity.
In cases of doubt, the standing orders of the Assembly shall be interpreted in light of the relevant usage and practices of the House of Representatives. So, in other words, it seems to suggest that if something is not provided for in the Tobago House of Assembly's standing orders, and it is clear that there's no provision there which deals with the issue of when someone resigns or is expelled from the party which elected them to office in the THA. There's nothing there. So the question is, can we now have regard to what occurs in the national parliament? Can we have regard to the usage and practice in the national parliament, in the sense that we have the clear wording of section 49 2E of the Constitution, which basically says, look, in such a case, you must vacate your seat.
Okay, so the truth is that Martin said a lot in this clip, and to unpack it in a way that would make sense to you, we need to first define what he's talking about, so we are all on the same page. Because if we don't, you truly have no way of contextualizing what he's saying to you. So what is Martin George talking about? Well, Martin George is talking about two sets of things. The first set of things he's talking about are the THA Act and the Constitution of TNT, of which the THA Act is a part. The second set of things he's talking about are the standing orders of the Tobago House of Assembly and the House of Representatives standing orders. So let's talk about the standing orders first. However, instead of me telling you what they are, let's see how those standing orders define themselves. The standing orders of the Tobago House of Assembly is defined in the THA Act itself as having been created for the safe custody and use of the seal, the regulation and conduct of the proceedings and meetings of the Assembly, including records of proceedings of the Assembly, the maintenance of order in the chamber of the Assembly, the conduct of debates in the Assembly, the suspension of members, and F, such other matters as the Assembly considers fit. So from this you can gather that the standing orders of the Tobago House of Assembly really refers to how business is conducted in the Assembly. For instance, when the House meets, how do the proceedings begin? When questions are to be asked, what's the format? As in, who talks first, how should the questions be phrased, etc., etc. Now let's see what the House of Representatives standing orders say about itself. So it says here, these standing orders contain rules for the conduct of the proceedings of the House and for the exercise of the powers possessed by the House. They are not intended to diminish or restrict the rights, privileges, and immunities of the House and its committees collectively or its members individually. So its definition, though short and sweet, is doing pretty much the same thing. So that leaves us now to define the role of the other two documents, the Constitution of Trinidad and Tobago and the THA Act. We will start with the Act. However, instead of actually giving you a definition, I'd like you to allow me to do something else first. I'd like to pick a subject, in this case, minority leader, and I'd like to show how the THA Act treats with it. And then I'll show you how the standing orders of the Tobago House of Assembly deals with the same subject. So here's the first mention of minority leader in the THA Act. It says, immediately after administering the oaths of office to the Chief Secretary and the Deputy Chief Secretary under Section 8, the President shall appoint as minority leader the assemblyman who, in his opinion, commands the support of the largest number of assemblymen who do not support the Chief Secretary. So in its first mention, the Act defines what is a minority leader. Okay, so keep that in mind for a sec. And bear with me as we now take a look at the first section of the standing orders of the THA that speaks to the minority leader. Here's what it says. Appointment of a minority leader. Immediately after administering the oath or affirmation of office to the Chief Secretary and Deputy Chief Secretary, the President shall appoint a minority leader in accordance with Section 8 of the Tobago House of Assembly Act 1996. Notice the difference. It does not tell you what a minority leader is. It doesn't tell you it here, nor does it in any of the other 14 or so places where the phrase minority leader is used. In other words, you can read the THA standing orders from now till thy kingdom come, and you would never know what a minority leader is. Why? Because the THA Act is what defines what the THA is in law, what its roles and responsibilities are, how representatives are elected, how they demit office, etc., etc. Oh, and also, obviously, what a minority leader is. We simply do not look to our standing orders for definitions. And we most certainly do not look to someone else's standing orders for definitions. Because that is not what standing orders are for. Standing orders are about procedures. Having said that, you could well imagine that all that I just showed you applies in similar fashion to the Constitution of Trinidad and Tobago with respect to definitions of what is and what isn't. So no need to go into that. So with that bit of understanding, we can now go back to pieces of Martin's video to understand what he's talking about. So let's go.
In cases of doubt, the standing orders of the Assembly shall be interpreted in light of the relevant usage and practices of the House of Representatives.
Okay, so this is a screenshot of the section of the standing orders of the Tobago House of Assembly Martin is referring to. It's called Section 92. Of course, it's a little small on the screen, so I've copied and pasted it in a format that's easier to see on the screen. So the question is, to what does the phrase usage and practice refer? The usage and practice phrase is in reference to the use and practice of the House of Representatives in terms of how it conducts its business. In other words, the usage and practice of the House of Representatives standing orders. So if the THA for some reason didn't cater for some scenario that comes up in the day-to-day running of the House via its own standing orders, it will consult with those of the House of Representatives. Now, if for some reason you happen to still believe that I may be misreading it, meaning that you believe it's possible that Section 92 of the Standing Orders of the Tobago House of Assembly is asking that in matters where there is doubt, the THA should refer to the T&T Constitution, rather than my suggestion that it is actually saying to refer to the House of Representatives Standing Orders, then I would advise you to take a look further down the graphic to what's written in yellow. As before, it's difficult to read, so I've rewritten it for you so that it is easier to read, and I've also highlighted the section in yellow in bold for you. It says, no restrictions which the House of Representatives has introduced by standing order, blah, blah, blah. So notice it didn't say no restrictions which the House of Representatives has introduced by law. It says introduced by standing order. And it says so because what it's talking about is one set of standing orders versus the next. So we are talking about one body, the THA, employing from time to time another body's rules for running its day-to-day business. We are not talking about consulting the laws that govern that body to then be applied to ours, as Martin has asserted. As a matter of curiosity, let's see if the House of Representatives standing orders says anything of a similar nature. So it says here, in any matter not provided for in these standing orders, resort shall be had to the usage and practice of the House of Commons of the United Kingdom, which shall be followed as far as they may be applicable to this House, and not inconsistent with these standing orders or with the practice of this House. Sound familiar? So if for some reason a case or scenario that has never been seen occurs in the running of the proceedings of the Trinidad and Tobago House of Representatives, it will defer to the standing orders of the House of Commons. For those who are not sure, that's in the UK. By now, you should be reasonably assured that the House of Representatives is surely not consulting the laws of the UK. And so in the same way, we are also not consulting the TNT Constitution either. Because as you can tell, we have used the same phrasing almost word for word, and that is because they have the same meaning. So having dispensed with that, let's hear from Martin again.
So, in other words, does that trump this to say, well, look, the fact that the THA Act is silent on it, can we use the standing orders in this way to bring in the relevant provisions of the national parliament to say, look, under the Constitution, by section 49(2)(e), the members of the THA who no longer belong to the party which elected them to office must resign?
So there are two issues with what Martin just said. One of which I think I may have already addressed when I distinguished between the law, the THA Act, and the Constitution, and standing orders. So let's deal with the part of the clip that says, can we use the standing orders in this way? To be clear, you cannot look to standing orders for definitions, only procedures. And the definition in question is, how does one become removed as an assemblyman? Not how does one be removed as an assemblyman if he resigns his party. The other part of what Martin asserts that is problematic is the idea that the THA is silent on what happens to the seat of an assemblyman if he leaves the party he originally was a member of when he or she won their seat. And I think it's problematic because if I list the ways you can be removed, then by definition you cannot be removed any other way. The fact that I haven't commented on all the ways you cannot be removed should not be characterized as silence. At any rate, seeing that we are here, let's tackle this so-called silence to see if it's actually deliberate, which I think is the point Martin may be trying to get at. To do so, I'll start with taking a look at all the occasions where the word party is used and see if that can help us make a determination. The first instance of the appearance of the word party in the THA Act is in section 19(2)(a), where it says, the President shall revoke the appointment of a councillor on the advice of the person or party which nominated him, or by reason of any of the matters set out in subsection 1. Okay, now let's look at the second time the word party is mentioned. In section 21(5), it says, where the appointment of a councillor is revoked or vacated, the party that, or persons who, as the case may be, nominated the councillor shall nominate a person to be appointed thereto at the meeting of the assembly next following the revocation or vacation of the appointment. So now let's look at the third and last time the word is used. In section 55, it says, legal proceedings pending immediately before the coming into force of this act by or against the former assembly may, on the coming into force of this act, be continued by or against the assembly as the party to the proceedings instead of the former assembly. Okay, so let's make some observations. Firstly, the third occasion isn't about a political party. It's really talking about the fact that in spite of the fact that there may be a new assembly, presumably one that was just installed because of an election, this new iteration of the assembly will automatically become part of whatever pending legal proceedings that previously involved the assembly. So if I sued the assembly, I didn't sue the one before the election. I sued the assembly, and that lawsuit is still valid. With respect to the second and third occurrences of the word party, it is clear that whomever wrote the entire act was fully aware that people may come into office as independents or as members of a party. And this point is very relevant to the discussion of the supposed silence of the THA on the matter of what happens if an assemblyman leaves the party he won the election with. So let's dig a little more. Notice that in the first instance, where the word party is used, it is saying that the councillor can be removed by the advice of the person or party that nominated him. In other words, you were not elected. Someone put you there, so that someone can choose to put you out. But if you look closer, you'll notice that above that is the very section that this entire discussion is about. It is section 19.1, and it spells out exactly the 4 conditions under which an assemblyman can be removed. And they are, if that assemblyman dies, as in A; B, if that assemblyman submits a written resignation to the presiding officer, etc., etc., or C, is without the leave of the assembly continuously absent from Tobago for more than 90 days, or from 3 consecutive ordinary meetings of the assembly, or D, ceases to possess any of the qualifications required by section 15.1, or is or becomes disqualified from being a member for any of the reasons set out in 15.2. So those are the reasons. The question is, were these 4 conditions, and only these 4 conditions, deliberate? Well, in this very document, literally right after defining how an assemblyman can be removed, where no mention is made of being removed on the say-so of the assemblyman's party, the definition of how a councillor can be removed follows. And in that definition, the framers tell you that a councillor can be removed on the say-so of his or her sponsor, be it a party or a person. So in the former case, with the assemblyman, it doesn't say so. But then right after, with respect to the councillor, it does. Yet some are suggesting this was an oversight. Perhaps ironically, I think the best evidence of how purposeful this was comes from Mr. George himself in this, the last clip I'll play from him. And yes, he does seem to be having a little bit too much fun with this, hence the question about his boredom.
But the interesting aspect of it is that the THA Act appears to have been specifically silent on this point, even though it was drafted after this 1978 amendment to the Constitution. So in other words, in our Constitution in 1978, we made this amendment for what is known as the crossing the floor provision. Right? So in other words, if you cross the floor and you leave your party or you're expelled from your party, you have to give up your seat, a by-election is called, etc.
So you heard that? Yes, the very Crossing the Floor Act, written in 1978, to which Martin George refers, was put into the Constitution because it wasn't there before originally. And from this, you can glean at least 3 things. 1, that even after what was surely a landmark piece of legislation only 2 years before, as you know, the THA Act was written originally in 1980, A.N.R. Robinson, who had by then been a fairly seasoned politician, who had occupied the heights of political office, simply refused to saddle our THA with the same kind of thing, on purpose. Number 2, if you want to change the law, you change the law. You don't try to fool people by telling them that standing orders can somehow replace law. And three, probably the reason such a law wasn't there in the beginning is because that which we copied from England didn't include it in their version of the Westminster system. Indeed, up to this day, there is no such law against crossing the floor in the UK. None. So do you still believe the THA is silent on the matter as Martin would have you believe? Or is the THA pretty purposeful? For my part, I don't believe the act is silent at all. In fact, the act is loud and clear if only we would listen. All right. So now for some commentary. All right. So for my 2 cents, while there have been many arguments about what has recently transpired in the THA and what it all means, there are two that have captured my attention the most. The first is the one that says people voted for the PDP. And if you resign from the PDP, then what we voted for no longer exists. And therefore, we should go back to the polls. Aside from the fact that, as was shown, this isn't provided for in the Act. Let me say the following. This argument reminds me of when people say that our foreparents died for our right to vote. Yes and no. What they actually died for is our right to be represented by people whom we believe could represent our interests. And the way you get people to represent your interests is by voting for them. In other words, voting is the mechanism by which we secure representation. But what if every time you vote, you were guaranteed that you would not be represented? Then the ability to vote would come to mean nothing, because it would no longer be producing the true result you wanted, and that is representation. In the same way, people who voted for the PDP did not vote for the letters PDP. They voted for an entity they believed stood for certain things. And to a large extent, they voted for people whom they believed stood for those same things. The fact that those people have left the entity doesn't mean they no longer stand for those things. In fact, they may have even left the PDP because it no longer stands for what they stand for. And so, to remain consistent and true to what they stand for, they have departed, hopefully, to form another entity that will represent those ideals in a more permanent fashion. So, the question I believe one must ask, if you voted for the PDP, is whether or not you believe the representative you voted for still stands for the things you formerly believed he or she stood for. And truthfully, only you can answer that for yourself. The second argument. The second argument is one that says, if you came in on one party's banner, it means you rode that party's reputation to victory, and therefore it is the sole reason you got elected. And so, if you leave it, you should also leave the seat you won because of it, the party that is. I happen to think this argument has some merit, depending on where you are talking about. In the US, for instance, the place is so large that most often people know nothing about the person they are voting for, other than what is scripted for them on the TV. And so, they simply vote along party lines. I happen to think this is often the case in Trinidad as well. Honestly, though, I don't know how true this is in Tobago. In fact, what the parties in Tobago do as a matter of course around election time is go looking for popular and trusted Tobagonians in each village whom they believe to be electable. And they then put those persons to run under their party banner. In other words, people whom the villagers would vote for because of who they are, not necessarily because of your party, though some of that might be in there, I suppose. The bottom line is that under those circumstances, it is probably unethical to claim the person's victory as all your own when you went looking for people whom you thought could win all along. And this brings me to my final word on this topic. I have had, for some time, major issues with how the Westminster system is applied to these Caribbean islands to disastrous effect. It gives our politicians far more power in our small island states than the same system when applied to these larger countries. If interested in a video that explains how, say so in the comments and I'll make it. By contrast, however, Robinson and his helpers actually created a document that was at least culturally sensitive to our local situation. And by that I mean, they knew that our representatives wouldn't be the ones manufactured on TV like in those bigger countries. Our representatives would actually be people we like, people we trust, people we know, and that we actually would vote for them. And so he purposely found a way to interweave and codify how we live as a people into a living, breathing document. And quite possibly the only one of its kind in these small Caribbean states. And so, yes, he chose not to give you, Mr. Political Party, the power to remove the people we put there. Why? Because contrary to popular belief, we are voting for them oftentimes and not necessarily for you. At the end of the day, we spend a lot of time talking about country first, or in our case, island first, before party. If we want that to be the case, we cannot enshrine just the opposite in our laws. We do not want to make it such that people are so stuck and beholden to the party that even in instances where they see wrongdoing that goes against us, the people, they cannot walk away without the threat of no longer being able to represent the very people who put so much faith in them. At least, I don't want that. Good day.